Iloilo Palay and Corn Planters Association Incorporated versus Feliciano. 13 SCRA 377, number L-24022, March 3, 1965. This is for persons and family relations, particularly first paragraph, Article 7 of the Civil Code, which provides that laws are repealed only by subsequent ones, and their violation or non observance shall not be excused by disuse or custom or practice to the contrary. Subtopic: Repeal. Repeal of a law is the legislative act of abrogating through a subsequent law the effects of a previous statute or portions thereof. Repeal is either express or implied. An implied repeal takes place when a new law contains provisions contrary to or inconsistent with those of a former, without expressly repealing them. Take note that repeals and amendments by implications are not favored. Facts of the case. This case was about the alleged conflict between two laws regarding importation of rice. Respondent Feliciano, then General Manager of the Rice and Corn Administration, urged the President to import rice in view of national emergency. Said request was in accordance with RA 2207. The same was recommended by the National Economic Council and hence approved by the President and its cabinet members. Petitioners, Iloilo Palay and Corn Planters Association, argued before the Supreme Court that said importation was not valid because it is contrary to RA 3452, which in its Section 10 provides that the importation of rice and corn is only left to private parties and not to the government. Petitioners further claimed that the law relied upon by Feliciano, which was RA 2207, was already repealed by RA 3452. For its defense, Feliciano maintained that RA 2207, which authorizes rice importation by the government in cases of national emergency, was still valid. The issue, whether law RA 2207 was repealed by RA 3452. The Supreme Court said no, RA 2207 was not repealed by RA 3452. Under the presumption against implied repeals, the legislature is presumed to know the existing laws, so that if a repeal is intended, the proper step is to so express it. Hence, the failure to add a specific repealing clause indicates that the intent was not to repeal any existing law, unless an irreconcilable inconsistency and repugnancy exist in the terms of the new and old laws. In this case, the court held that the repealing clause, which provides that all laws or parts thereof inconsistent with the provisions of this act are hereby repealed or modified accordingly, found in RA 3452, is certainly not an express repealing clause because it fails to identify or designate the act or acts that are intended to be repealed. The court also ruled that there was also no irreconcilable inconsistency and repugnancy in terms of RA 2207 and RA 3452, as the two laws, although with a common objective, refer to different methods applicable to different circumstances. RA 2207 merely contemplates importation during normal times, while RA 3452 was intended to address importation when there is a shortage in the local supply of such gravity as to constitute a national emergency, which was present in the case. Said two laws, therefore, are not inconsistent, and so implied repeals does not ensue, or in other words, must not be favored. Therefore, in applying the foregoing, the Supreme Court ruled that RA 2207 was not repealed by RA 3452 and dismissed the petition.